So whenever we get any confusion, what the act or what the law talks about, first of all, we have to go for primary rules. How many rules are there? Seven. Okay. So you just see the meaning. If the grammar, if the line is very clear, if it's very plain, then no, you should just follow it. It is not clear. It is giving two different meanings. That which one has to be taken. Sometimes we have to go for exceptional side. Sometimes we have to go for beneficial side. Depends. Okay. It's not like we shall take that one or this one. It's not that way. We have to take in that particular sense where the lawmaker has done the thing. Okay. Apart from primary rules, we have two secondary rules here for discussion. One is actually this is called as secondary rules. That's why we name this as doctrine. Doctrine means what? If this follows, then we can apply this one. Okay. First one is doctrine of nocister e solis, and second one doctrine of contemporino exposito. What do you mean by contemporary? To that part. Okay. I have an act, and this act is when enacted. Go for the date. For example, I'm talking about Companies Act, not 2013, 1956, just for example. So we are talking about 1950s, which means soon after independence. So what was the position of India over there at that time, and how we have to understand the law? That is how we have to construct the law. See, like after 63 years of 2013, after 63 years only we are getting this 2013 Act. Am I right? Why we need this Act? Because this has to become a contemporary to other acts and we have to compete with other nations. So when we talk about 2013 Act, we'll go what was the law and what was the situation at that time and why this act was enacted. We have to understand this sense. So contemporary means எப்போ இந்த law வந்தது அந்த டைம்ல என்ன இருந்தது situation அந்த மாதிரி பார்க்கிறோம். Whereas if you go for this one, no sister solis, this is nothing but it will give some proper meaning. Like it may look like it is giving a plain meaning, plain grammar meaning. For example, if you go for this fresh orange juice, see the juices word is there. What do you mean by juice? What do you mean by juice? ஐயோ இதற்கு எனக்கு பச்சதே இல்லையே. ஜூஸ்னா குடிக்க தெரியும், பார்க்க தெரியும். ஜூஸ்னா என்ன சொல்ல தெரியல. And each and every law treats this juice differently. Under this Purchase Tax Act, it says fresh orange juice is not a fruit juice. That's what you call as juice. But what do you understand from this word? See, this juice should not be seen as juice. It should be seen as orange juice. இங்கு நல்ல மீன்கள் விற்கப்படும். Which means what you have to do? என்ன விற்கப்படும்? மீன்கள் விற்கப்படும். We have to go for one word earlier. That is usually for descriptive side, we have to go from the last. Okay, we have to go in the reverse order. What is there? Juice is there. What juice? Orange juice. Orange fruit. Okay. Tomato also can be taken. Juice means what we are going to define. We don't go for the book meaning for juice. What do you want? We go for a normal plain meaning. That's about principle of literal construction. Am I right? What the law says? Understand in a plain meaning. If the plain meaning is clear, why you complicate? Beetle leaves. Why you complicate? Take it as beetle leaves. Why you give some biological meaning and all? Not necessary. So juice means, okay, it's clear. What we say? It's an extract of a fruit or vegetable, whatever it is. Orange juice, okay, orange is a fruit, so covered under here. Yes, the content here is about fresh oranges. Fresh orange juice is not considered as a fruit juice. So this is as per Purchase Tax Act. Okay. So what do you mean by doctrine as solis means when two or more, so let me go from this doctrine. When two or more words that are susceptible of analogous meaning, which means it's not one single word we are talking. If one single word we take, it looks very simple. But what happens? We have to look as a phrase. When two or more words, which means when we talk about the full phrase, and that is giving some analogous meaning, which means it is like clear, it's not clear. வெறும் orange juice கொடுத்திருந்தா clear ஆ இருக்கும். But it's given as fresh orange juice. See, whenever a word is included in the act, you make yourself sure it's not just like a hobby it was introduced. போர் அடிக்குது பண்ணிட்டு போலாம். எனக்கு எழுதுறது passion. அப்படியெல்லாம் கொடுக்கல. There is a word fresh means there's some meaning behind that. So go for the analogous meaning. As they are coupled together, please highlight this word coupled. It means what? Joined. So that they have to be understood in their cognate sense. What do you mean by the term cognate is, I'm not exactly defined in English class எல்லாம் எடுக்கல, okay? மேம் வேற மாதிரி சொன்னாங்க, இங்க வேற மாதிரி. Cognate sense means at what sense these words are framed, at what sense these words are coupled. They take as it were their color from each other. Their color is not color, okay? They say the meaning from each other. That is the meaning of more general word. Please highlight. If you understand these two star mark, then it's very comfortable for you. You should not understand this is a normal word. You have to consider this more than the general word, being restricted to a sense analogous to those that are less gentle. So why we are going to say here, fresh orange juice is not a fruit juice. So this is then from Purchase Tax Act, which use the expression Purchase Tax Act law. We are saying this expression, manufactured beverages, including fruit juices and bottled waters and syrup. What do you understand? Please go through. Please go through. At least give 3 reading word by word. Can apply rule of agistum generis if you want to. Not exactly the same, but more or less it will overlap. It says manufactured beverages, including fruit juices, bottled waters, and syrups. இங்க fresh fruit juice வந்துச்சு. What do you mean by fresh fruit juice? ரொம்பலாம் காம்ப்ளிகேட் பண்ணிக்க வேண்டாம். அவங்களே சொல்லியிருக்காங்க பாருங்க. யாரு ஜட்ஜே சொல்றாரு ஃப்ரெஷ் ஃப்ரூட் ஜூஸ் தான் என்னன்ட்டு. அது ஜூஸ் கடைக்காரங்கிட்ட கேட்டாப்ப சொல்லுவாங்க. Okay. So I hope everybody will like juice. During the summer, if you go to a shop, either you go for preferring Elanir, tender coconut, or you go for juices. You search for a juice shop. What juice you have? Mosambi, pomegranate. Okay, Mosambi விட்டுருங்க. அது ஆரஞ்சு லெமன் புளிஞ்ச மாதிரி தான். Go for pomegranate juice. Pomegranate like எக்கச்சக்கமா கொஸ்டின் கேட்பான். Usually when you go to a juice shop, two questions will be asked. ஐசா மேம் without ஐசா. Okay, juice கடைக்காரங்க போலே பேசுறீங்க மேம். ஐசா without ஐசா. Okay. Next question, if you are ordering pomegranate, what will be asked? Milka without milka. Sugara without sugara. Probably for lemon juice, you may expect this question. Sugara, salta, soda எல்லாம் இல்லையா? Okay, but when we talk about pomegranate, whether pomegranate juice, fresh pomegranate juice சாப்பிட்டுருக்கீங்களா? ஃப்ரெஷ்னா அப்பவே அரைச்சு கொடுக்கறது அந்த ஃப்ரெஷ்ஷா மீன் பண்ணல. Here the meaning fresh is taken, pressed and directly served. No sugar added, no water added, no milk added. Milk add பண்ணா the milkshake. Okay, here they will not add milk. They will not add sugar or honey or any sweetener or salt also. And they will not add water also. Okay. இன்னும் உங்களுக்கு கிளியரா புரியணும்னா வீட்டுக்கு போகும்போது ஒரு மாதுளை வாங்கிட்டு போய் ஜூஸ் போட்டு சாப்பிட்டு பாருங்க கிளியரா புரியும் வாயில வைக்கவே முடியாது அதுனா ஃப்ரூட்ஸே சாப்பிட்டுருவேன் ஏன் எப்படி படுத்துறீங்க பிகாஸ் இட் வில் நாட் ஹாவ் எனி எக்ஸ்ட்ரா டேஸ்ட் இட் வில் ஹாவ் த நேச்சுரல் டேஸ்ட் ஃப்ரூட் சாப்பிட்டுருப்பீங்கல்ல பொமிகிரானேட் ஃப்ரூட் அது எப்படி இருக்கும் சம்டைம்ஸ் புளிப்பா இருக்கும் சம்டைம்ஸ் இட் வில் பி கிவிங் சம் ஸ்வீட் டேஸ்ட் ரொம்ப திகட்டும் சம்டைம்ஸ் வந்து நீங்க என்ன வாயில வச்சு அது ஃப்ரூட்டா அப்படின்னு தோணும் இட் வில் நாட் ஹாவ் எனி ஸ்வீட்னஸ் இட் வில் நாட் ஹாவ் எனி சோர்னஸ் ஒரு மாதிரி கசப்போம் கசக்கிற மாதிரி இருக்கும் பிட்டர் டேஸ்ட் இருக்கும் so you will call this only as juice because when you go for manufactured beverages because we have to link with the purchase tax act definition when you say manufactured beverage for example coke you buy coke in Trichy you buy coke in Chennai you buy coke out of Tamil Nadu you buy coke out of India same taste எத்தனை பேருக்கு கோக் பிடிக்காது எப்ப சாப்பிட்டாலும் கோக் கேவலமா தான் இருக்கு அப்படி சொல்லுவீங்க அதுவும் இந்த இது பிரஷர் கேஸ் போச்சுன்னா அவ்வளவுதான் அது ஏதோ கலர் தண்ணி மாதிரி தான் ஆகும் ஓகே manufactured beverages now come for the other words here including fruit juices bottled water and syrups when you look after these words see you should not look after a single word see this is the doctrine of Nosister says what it says you have to you should not see a single word you have to couple the words okay so if you see in that meaning you should not see this as exactly as one single word syrup you should not see this as just bottled water you should not see this as fruit juices just fruit juices but how manufactured beverages including fruit juices எல்லாம் டப்பாலே வருது packed Endocovenant pact version வருது. And most of the juices probably and the ORS இதெல்லாமே வந்து you can get it in bottled and packed waters. அப்ப என்ன? How can you say this is fresh? Fresh is not only saying fresh, fresh means அப்பவே வந்து கம்ப்ளீட்டா வந்து see ஜட்ஜ் சொல்லி பாருங்க. Okay. It was held that the description, fruit juices as occurring therein, should be construed in the context of the preceding words. Please highlight preceding words. And that orange juice is unsweetened. Everyone is holding unsweetened. But taste illa. How the description is given? Fresh orange juice. Fresh orange juice means the term fresh carries no water, no milk, no etc., no sweetness. So unsweetened and freshly pressed will not be covered under this description. So what is this doctrine talking about, Bob? What is this secondary rule talking about? Don't see a single word. Even though if you apply the rule of literal construction, it will say that you are applying the direct meaning, plain meaning, grammatical meaning. What this doctrine says, this actually secondary one. What this doctrine says, it clearly says, don't see as a single word, just couple. So it's a small thing. Likewise, private dispensary, I'm not going to go word by word, of a doctor is not a commercial establishment. If a doctor is having a private clinic, he's visiting government hospital, okay, he's visiting other clinics. Apart from this, he is having a private dispensary. It's not considered as a commercial establishment. Every month சொல்றீங்க அதுல business மாதிரி தான் run பண்றாரு. The act, which act? Bombay Shops and Establishment Act says this is not covered. Okay. So that's the first doctrine. Shall I take over? Second doctrine, as I discussed earlier, whenever you talk about the act, you have to check what was the situation, what was the circumstance over at that time, then you have to compare with it. So, doctrine of contemporaneo exposito. Okay, before continuing, probably I might have discussed in earlier class. What do you mean by act? What do you mean by bill? You remember? This what do you mean by bill? Yes, the draft which is yet to be enacted. Once it is enacted through Lok Sabha, Rajya Sabha, and President as it becomes an act. You know everything. Ordinance without the two houses of parliament. Lok Sabha and Rajya Sabha, due to the emergency situation, we need it to be enacted. We need to follow as act temporarily. So President assent is enough of that time. Okay. Apart from this, probably you might have seen this term called as code in the title. There, for example, Indian Penal Code, Civil Procedure Code, Criminal Procedure Code. இவ்வளோ codes இருக்குல்ல இந்த codes எல்லாம் now we have this labor code of wages act. We have earlier we had separately payment of wages act, we had minimum wages act, we had payment of bonus act, and we had equal remuneration act. Now all these four acts are scrapped and we have one single code, which means you need to try to understand what do you mean by act and what do you mean by code. When we say code, it's applicable always. For example, I'll go for a defamation case. What do you mean by defamation case? ஒருத்தவங்களை பத்தி தப்பா பேசினா defame பண்றது. Okay. Defamation case. I defame a person in a public meeting. That should not be done. Okay. If there's a personal vengeance, that should not be done actually. I'm not defaming a person in a public meeting, but instead I'm defaming through WhatsApp message. அப்போ இந்த ஐபிசி சிபிசி சிஆர்பிசி எல்லாம் வரும்போது வாட்ஸ்அப் ஐடி எல்லாம் இருந்ததா இல்ல even though that was not there at that time, what's the theme behind this all the three codes? It's about defaming. All these IT social media was not present at that time. Currently we have, but still those codes are applicable. இப்போ ஐபிசி எல்லாம் இல்லை இப்போ தெரிஞ்சு இது பிஎன்எஸ்எஸ் அதெல்லாம் இருக்கு மாறிச்சு. It's completely changed. So, doctrine of contemporaneo exportizo, if you are applying this act today, just think when the act was enacted and what was the circumstance at that time and why that act came at that time and why we are applying here today as if the circumstance is happening today. Okay. So, let me go word by word. This doctrine is based on the concept that a statute, not only for statute, even for a document, is to be interpreted by referring to the exposition. What do you mean by exposition? Expression. Exposition means how it is being expressed. That's what you call as exposition. It has received from contemporary authority. Who was that at that time? Who was there and what was being for? So the maxim we follow here is contemporanea exposition est optima est fortius in leg, which means contemporaneous exposition is the best and strongest in the law. Okay. So if you have any doubts, if you want any clarifications about Companies Act 2013, we'll just look after what was happening at that time. Okay. Companies Act 2013, திடீர்னு ஒரு மாசம் 2 மாசம்லாம் வரல. If you go for the background work, we were working for almost 5 or 6 years. அப்போ இந்த 5 or 6 years தேவைப்பட்ட விஷயம்லாம் 2013 ஆக்ட்ல போட்டாங்க. அப்போ இவ்வளவு விஷயங்கள் தேவைப்பட்டிருக்கு. That's what contemporary. So if you understand the circumstances why we need all these things, then it becomes the best and strongest law to understand, to interpret, to construct. Okay. So this means a law should be understood in the sense in which it was understood at the time when it was passed. You can please highlight this. So the maxim optimum, optima is optimum, legum interpres est consequent. Simply means custom is the best interpreter of law. If you have any doubt, for example, if you follow our law, what is our law? We have so many laws. If you follow India, culture based, we have religion based law, custom based law. So if you follow our law, what was the custom at that time? Follow that one. Religion based law. Okay. I think there'll be an example. No example. Okay. So the court was influenced in its construction of a statute of Anne by the fact that that generally considered as a true one for 160 years. Okay, we are following this law for many number of years and we follow now also. That's a custom here. Okay, so this maximum is to be applied for considering ancient. Yes, please come. Please highlight this one. It's not for the modern law. We have to consider this for ancient laws. 100 years மேல இருக்குல்ல ஃபாலோ பண்ணிட்டு இருக்கோம்ல வழிபடியா ஃபாலோ பண்றோம். You cannot raise a question over there. That those time only cannot. Okay. Okay. So let me continue. If you want to go through, yes, please. We'll go for the next heading. Internal aids, support to interpretation or construction. See, only when you get the question as whether this is interpretation or construction, we have to define difference between interpretation and construction. Generally, we can interchange the words and use it. So, what are the different aids we have? One is seeing the title of the act, you can clearly understand what the act is going to talk about. When we say the Companies Act 2013, when we say the Limited Liability Partnership Act, or when you say Indian Contract Act, seeing the title, you can understand what the whole act is going to talk about. Other could a 400 page, 500 page. Title of a Okay. Again, if you go inside and you see some provisions and if you want some more clarity about the provision, go and refer the title name. It will give you some more interpretation. Okay. Second is preamble. Usually when we say preamble is a summary of the act. Usually when we say the word summary, it will be given at the end. But this is such a beautiful content. Instead of going at the end, you can understand the whole act by just 2 or 3 lines given in the beginning of the act itself. Okay, usually I say this is like a trailer, movie trailer. ஒரு ட்ரெய்லர் பார்த்தா எப்படி இருக்கும் நாட் டீசர் டீசரை பார்த்தாலும் சொல்ல முடியாது just it will be giving some posture looks. Okay, when we say trailer, it will give a sequence of movements where you can understand whether the main theme, whether it's talking about a action movie or thriller movie or horror movie, mystery, whatever it is, you can guess from that. Okay, horror movie எப்படி கண்டுபிடிப்பீங்க படத்துல ஒண்ணுமே தெரியாது இருட்டா இருக்கும் எல்லாம் முடிய வச்சு போட்டிருப்பாங்க இப்படிதான் ஹாரர் மூவி கையை மட்டும் காமிப்பாங்க அந்த சைடு 4 பேர் போய் விடுவாங்க அப்படி பார்த்தா ஓ இது ஆக்ஷன் மூவி எனக்கு ஆக்ஷன் மூவி பிடிக்காது நான் போகல எனக்கு ஹாரர் மூவி பயம் நான் போகல you can decide. So if you find any difficulty in understanding the act, go through the preamble, please read it. It will give you, see, all these things are not going to override that. See, it's supporting aids. It's not the rule. Please try to understand it's supporting aids only. So you're not going to override the provision. Only the act will be override. Okay. Second one, preamble is just summary like. Third one, for each and every chapter, we'll be having a heading. So if you go for chapter 2, incorporation, under the Companies Act 2013, So if you want to have any idea about incorporation or any rules or what are the affidavits and what are the name you have to give to the company, what you can do is you can go for referring chapter 2 directly. Likewise, administration, management and administration, go for chapter 7 and so on. Okay. It will give the heading. Apart from this, we have fourth one, marginal notes. And the section என்னென்ன இருக்கும் incorporation of a company related procedures இருக்கும் அது என்ன marginal notes மாதிரி எடுத்து வச்சிருப்பாங்க. Okay. Fifth one, definitions. Already we have this General Clauses Act. Already we'll be having section 2. So we'll be defining the terms, the definitions in that provisions. And obviously we have to apply them. And why we have these definitions? To shorten the language. Okay. Sixth, sometimes to give clarity, they will illustrate with a small example. 7, proviso. Yes, you very well know proviso means provided that, which means you have to follow this. It's a restricted provision. Only if the following things are followed, you can apply. Explanation will be there probably when you define share capital. Okay, when we talk about share and share capital, what do you mean by shares? We have equity share with ordinary rights, with the differential rights, preference shares. Then below that, they'll explain what do you mean by equity share. There will be an explanation saying that point 1, point 2, what do you mean by preference share? It will be explained below. Okay, so that's about explanation. Ninth one, we have MOA and AOA schedules, which is a proper format they are giving. எல்லாமே ஆக்ட்லயே கொடுத்தாங்கன்னா it will not have a continuity of meaning, so that's why these will be given as a separate schedules, like we can colloquially say as annexures. Okay. And 10th one, yes, very very important, please highlight, read the statute as a whole. One provision will be giving a different meaning, another provision will be giving a different meaning. Don't get confused. All together you have to look as a single meaning. Read the whole as a single statute. Okay. So we'll go one by one. First one, long title. It's quite very easy. So let me take up the speed. It's an enactment. What is known as short title and also long title. When we say short title, it will merely identify the enactment and is chosen merely for convenience. I say RTI Act. What is RTI Act? What is IT Act? No, Income Tax Act. நீங்க அப்படி சொன்னீங்கன்னா நான் அப்படி சொல்லுவேன். Okay, what is RTI? Right to information. See, each and every time I did not say right to information act. POXO. Okay. See, Peter, we have all these rights. See, whenever we use the short language, that is short title, it's not going to help you to understand the act. It's just helping you to why come here is I don't know that. Okay. So only we have to use the long title. So when we say long title, is actually describing. Please highlight these two words. Short title is identifying, long title is describing. And not merely identifying it. Okay. Not merely identifying, this is a generally short title. See, every act will not have short title. Okay. So it's now settled that the long title is a part of the act. Probably you may expect this as a course. We can therefore refer it to ascertain the object, scope, and purpose of that, and is admissible as an aid to its construction. Okay. So we can go for this example. It's related to a act called a Supreme Court Advocates Practice in High Court Act. What do you understand? Don't go through the other words. What do you understand from the title? Supreme Court Advocates வந்து ஹை கோர்ட்ல பிராக்டிஸ் பண்றதுக்கு உண்டான ஆக்ட் ஏதோ ப்ரொவிஷன்ஸ் இருக்கு அப்படின்னா என்ன அர்த்தம்? பிராக்டிஸ் பண்ணாதானே அர்த்தம். பிராக்டிஸ் பண்ணலாங்கிறதுக்கான ஒரு ஆக்ட் இதெல்லாம் இருக்குமா? We have SEBI LODR regulations, listing and disclosure obligations. அப்படின்னா இந்த கம்பெனி லிஸ்ட் பண்ணலாங்கிறதுக்காக இந்த ஆப்ளிகேஷன்ஸ் இருக்கு, இல்லைன்னா இருக்காதுல்ல. So specify that this act is to authorize advocates of the Supreme Court to practice as a right in any high court. It's a right. அப்படின்னா அவங்க பண்ண முடியுங்கிறதுக்காக ஸ்பெசிபிக் ஆக்ட் இருக்கு. So it's the right they can execute. Okay. So the title is an important part of the act and may be referred for that purpose of ascertaining its general scope and throwing light on its construction. Although, please highlight, this case law says it cannot override the clear meaning of the act. Act ஒரு மீனிங் தருது, உள்ள வேற மீனிங் தருது, உள்ள இருக்கிற மீனிங் தான் நமக்கு வேணும். And what's the 10th point? Read the statute as a whole. As a single statute, you have to read it. Understand as a single statute. So when you understand in that sense, don't go for the title side. Title is not going to override. Act is only going to override. And the full book represent ஒரு நேம் வேணும். நீங்க யாரு அப்படின்னு சொல்லிட்டு உங்களுக்கு ஒரு நேம் வேணும்ல அப்படின்னா அது வேற ஒன்றும் இல்லை. ஓகே. So relevance and significance. What is relevant here is it expresses the scope, object, and purpose. The preamble of the statutes is not preamble. What is the long title? Can you please correct it? The long title is a part of the enactment. Whereas if you go for the significance, can legitimately used for considering. What do you mean by legitimately? It's accepted lawfully. See, we say that long title is a part of the enactment, right? அப்படின்னா அது அழகா இதை வந்து நீங்க டிஸ்கிரிப்ஷனுக்கு யூஸ் பண்ணிக்கலாம், கன்ஸ்ட்ரக்ஷனுக்கு யூஸ் பண்ணிக்கலாம். Does not override the plain provision of the act, where if the wording of the statute give rise to doubts as to proper construction, the preamble, not preamble, long title can and now be referred to in order to arrive at the proper construction. That's why we call this as supportive one. It's not the main rule. Okay. So shall I continue? Preamble. Let me finish 5 and 5. Okay. Let me finish 5, then I'll give a break, then you can vote. Also, preamble looks similar to long title. Long title is just the title, whereas if we go for preamble, it will give a short summary. Expresses the scope, object, and purpose of that more comprehensively. Please highlight. So far, we have referred 3 terms. For short title, it was identifying. For long title, it was describing. And here, more comprehensive. More comprehensively than the long title. So it may reside. Please highlight. What do you mean by residing? அப்படியே ஒப்பிக்கிறது, அப்படி சொல்றது. ஓகே. ஏக்கு மேல ஒரு ஈ உட்கார்ந்துருந்தா ஏக்கு மேல ஒரு ஈ உட்கார்ந்துருக்கு அப்படி சொல்றது. ஓகே. See, residing means without changing its meaning. Reside the ground and the cause of making a statue and the evil which is sought to be remedied. So you have to get a remedy, right? ஒன்னு இருக்குன்னு ஒரு remedy இருக்கணும். Mischief. Like the long title, the preamble of the statute is part of the enactment and can legitimately be used for construing it. However, the preamble does not override the plain provision. Probably in the picture, இங்க வந்திருக்கணும்னு நினைக்கிறேன். அப்படியே மேட்ச் ஆகுது. It both matches for long title and preamble. If the wording of the statute give rise to doubts as to proper construction, where the words or phrase are having more than one meaning and the doubt is arising, means the preamble will help you to understand. Please try to link this with the rule of what is that second one? Reasonable construction. Rule of reasonable. You're getting 2 meanings. Which meaning to take it? Both may be having interpretation properly, which looks like both are valid. But which one you have to take it? Go for the preamble. Not going for title. Go for the preamble. Okay. So in short, preamble of an act discloses the primary intention, but can only brought as an aid to construction. It cannot override the provisions of the enactment. Can you go for this example? Example 8, please. So as per Hindu Marriage Act, I'm not going line by line, you can manage, okay. As per the Hindu Marriage Act, this section 5, talks about what is the gist of this act exactly, who and who can get married. See, we are talking about the title and the preamble, okay. It says Hindu marriage, so which means male and female, both should be Hindus. Here, the problem is not about understanding the gender-based religion and all. The problem here is given as main. Adina main or kudava. Already we have done this with General Clauses Act. It says that may means may only. It's not may not. It's mandated. So when they say may, so how you understand? See, the act name itself is Hindu Marriage Act, which means that Hindus only can get married. So one Christian male and one Hindu male, female is going for Hindu Marriage Act means they cannot apply. It's out of scope. Preamble and non-title both discusses about the scope, object, and purpose of the act. Okay. So an act to amend and codify the law relating to marriage among Hindus. Okay. So heading and title of a chapter, heading and title of a not the whole act, about the chapter. Okay. As we have long title for the whole act, we have the heading and title for the chapter. So if you want to have any reference, you can directly go for the chapter name and you can take it. If you want to know how the company to be incorporated, what are the provisions to be followed, go and refer that provisions, it will help you. Okay. So generally find a number of its section, please highlight number of its sections referring to a particular subject, those that are grouped together. Sometimes in the form of chapters prefixed by headings or titles. These headings or titles prefixed to sections or groups can legitimately, I want to highlight this word, legitimately, law body apply law. Okay. And the headings of different portions can be referred to determine the sense of any doubtful expression. It will give a clear-cut meaning saying this can be applied. And please highlight they cannot control the plain meaning of the words. In some cases, we looked at the light of preamble only. We cannot directly take it in a full actல இருக்கிறதோட just வந்து preamble இருக்கும் அது எப்படி full actல இருக்கிற just வந்து chapterலயே கொடுக்க முடியும் and moreover we have the 10th support saying that look as a whole. Okay. So it might be noted that headings may sometimes be referred to know as the scope of the section. Please highlight. Title and preamble are scope of the act, object, scope and purpose of the act. But here the scope of that particular section zone. In the same way as preamble. So this is how it's compared to preamble. A heading cannot control or override a section. We'll go for marginal notes. There's nothing but summaries and side notes which will be found at the side of the section or group of sections. For example, if you are talking about director's powers, already we have a chapter. It says completely dealing with the board of directors, management and administration, chapter 7. Even then, in the section siteல power of directors கொடுத்திருப்பாங்க. அப்படி கொடுத்தா என்னது மார்ஜின்ல நீங்க நோட்ஸ் எடுக்கிறீங்களா அந்த மாதிரி it will be easy for reference. Actually, it's not an see, they are not part of the enactment at all. Just for reference sake, they are using. They were not present. Please highlight. When the parliament passes the act, this is not present. Probably official inserted after the act has been so placed. Okay. So hence, they are not an aid to construction. Please highlight. Even if it is numbered as 4 in the list, don't consider this as aid to construction. Okay. So you can refer this one. I'm not going line by line. You can refer this bit later. Let me go for E. Already we have done this with Gender Clauses Act in detail. So I'm not going to go line by line. They have definition sections. Instead of this term definition sections, you call this as interpretation clause. If you have any doubt who is a director, go and refer the definition of a director. If you want to get any clarification about security, go and refer securities. Okay. Which means that one term clearly says. We have discussed this one now, officer and officer in default. Remember? Very beginning of the companies are we were discussing who is an officer in default. அப்போ எங்கேயாவது ஆஃபீஸர் இன் டிஃபால்ட் பாத்தீங்கன்னா அந்த டெஃபினேஷன் யாரெல்லாம் கவர்டோ அவங்கலாம் வந்துருக்கும். If it is mentioned just as officer, it gives a different meaning. Likewise, sweating with shares and ESOP, whether director is an employee or not. Okay, whether independent director will be covered for ESOP or not. To understand this, go and refer those director definitions, then come for employee. Okay, so definition section or what you call as the interpretation clause. The legislation has the power to embody in a statute. Please highlight. You need not go and refer General Clauses Act for each and every time. My act wants to have a separate meaning, exclusive meaning means go and refer the statute. Okay, which statute, which act I am applying for. Okay, it says the definitions in its language and okay, this is a normal part. So when a word or phrase is defined as having a particular meaning, is that meaning alone? Please highlight it. Is that meaning alone? Unless there is anything repugnant in the context. Contrary. So this is called an exhaustive definition and the court cannot ignore an exhaustive definition and try and extract some of the meanings and all. And the purpose of the definition, please highlight. Purpose of the definition is twofold purpose. Probably I can go for next page. It's given clearly in the next page here. To provide a key to proper interpretation and also to shorten the language. Only for these two purposes, we have something called as definition section or interpretation. And how you construct? Under the following headings, we have 3 types. One is restrictive and extensive definition. One is ambiguous definition. One is definitions subject to contrary. Subject to. Okay, subject to means what? Under some conditions satisfied, you cannot apply it. Okay. So first is restrictive and extensive. We have already done this. I'm not going line by line. We have already discussed mean and include. Include is nothing but listing, extensive definition. Sorry, include is nothing but listing. Okay. And mean is nothing but exhaustive, which means it is giving this is the meaning. நீங்களே ஓனா எல்லாம் ஆட் பண்ணிக்காங்க இங்க தான் meaning. But whereas if you go for include, it is giving a list. Includes this one, include that one, include this one, okay. So you say this as uh, what extensive definition. Okay. So you say this as prima facie extensive. What do you mean by prima facie extensive? Only if those words are expressed, you take it. Not expressed, you won't take it. Okay. So sometimes you'll be having this as means and includes. Sometimes to apply to an include. Okay. So all these are different terms you'll be using it. So I request you to go through all these. Sometimes it's deemed to include, for example, like private companies and all. If a private company is a subsidiary of a public company, then it will not be called as a private company, it will be called as a deemed public. So we'll be using this word called as deemed. Okay. Then second one, let me finish off the setting. Okay. Second one is ambiguous definition. Ambiguous means sometimes it contains lot and lot of meaning. So what type of definition will give you? Okay, so probably having regard to the ordinary meaning, how can you understand? Definition பார்க்கும்போது ambiguous which means what confusion, clarity இருக்காது, confusion okay. For example, if you go for debentures, it's not only long term debentures we are talking about. Any type of debt is also called in one angle is called as debentures only. Okay, so probably I'll go for this example. For this alone, I'll go for this example. Termination, please join with me. Termination of service of a seasonal worker after the work was over does not amount to retrenchment as per the Industrial Dispute Act. He's a seasonal worker. Okay. Actually, we are not applying any particular act. We are directly going for labor laws. So when you talk about labor laws, we have to go for Industrial Dispute Act. Actually, Industrial Dispute Act and லேபருக்கும் ப்ராப்ளம் வருது, லேபருக்கும் மேனேஜ்மெண்ட்டுக்கும் ப்ராப்ளம் வருது. ஓகே, இல்லைன்னா லேபர் கான்ட்ராக்ட் மூலியமா வந்தா கான்ட்ராக்ட் ப்ராப்ளம் வருது. அப்போ இது வந்து இண்டஸ்ட்ரியில நடக்கிற டிஸ்பியூட்னால இட்ஸ் கவர்ட் அண்டர் இண்டஸ்ட்ரியல் டிஸ்பியூட் ஆக்ட். Almost all the labor laws will be covered over here. So here is a seasonal worker. Okay, this seasonal worker is terminated once the work was over. They say that it's not considered as retrenchment. சீசனல் ஒர்க்கர் அந்த சீசனுக்கு ஒர்க் பண்ணவர் கிளம்பிடுவாரு. அது பிறகு நீங்க வந்து டெர்மினேட் பண்ண ஆக்சுவலா அந்த டெர்மினேஷன் ஒரு கான்செப்டே வராது. So you cannot call this as retrenchment. But the termination of employment of a daily wager who is engaged in a project or on completion of the project will amount to retrenchment. Please try to understand. Here we were discussing saying that seasonal worker will not be considered as retrenched. Whereas here we say he's a daily worker. Okay, daily worker na உங்ககிட்ட தான் ஒர்க் பண்ணிட்டு இருக்காரு. பட் ப்ராஜெக்ட் முடிஞ்ச பிறகுதான் நீங்க வந்து அவரை துரத்திருக்கீங்க. ஆனாலும் இது என்ன சொல்ல முடியாது, இது என்ன சொல்லணும், ரிட்ரென்ச்மெண்ட் சொல்லணும். பிகாஸ் இஸ் அ டெய்லி ஒர்க்கர். ஓகே, டெய்லி ஒர்க்கர்னா எப்பவுமே வேலை இருக்கும். ப்ராஜெக்ட் இருந்துச்சுன்னா எப்பவுமே வேலை இருக்கும். பட் சீசனல் ஒர்க்கர் அந்த சீசன் வரும்போதுதான். ஸோ திஸ் குவைட் a unique one, this one. And definitions subject to contrary. Okay, so when a word is defined to bear a number of inclusive meanings, in the sense in which the word used in the particular provision must be ascertained as per the context given in the scheme of that, which means you look out the language and understand subject to subject. So 5 headings over now. Can you please go through here? Sixth one, illustrations. Though not all sections have illustrations, it's not like each and every section they are going to explain with an example. Illustration is different from example, but colloquially interchange. So why we need to have these illustrations is we need to know what the sections and what is the context in the section talks about. And obviously they're not going to form a part of the section. For example, if you are talking about whether my company is mandated to go for CSR activities. Okay, CSR activity na pananuma in company அப்படின்னு வரும்போது they are giving the limitations with respect to have to have this much net worth, turnover, and net profit. This is 500 crores. If there is 500 and more, 500 crores and more, turnover 1000 crores and more, and net profit 5 crores and more, you have to go for. You will be mandated as per the CSR rules, we have to follow the CSR, which means we have to go for constituting a CSR committee and etc. Now I have a doubt whether this will be applicable for me as a private company. Okay. வேல்யூ எல்லாம் பார்த்தா பெருசா இருக்கு பிரைவேட் கம்பெனிகள் அது அப்ளிகபிள் ஆகாது சொல்ல முடியாதுல்ல. And the provisions actually it's followed from section 135 of the Companies Act. இங்க பாத்தீங்கன்னா every company ஸ்டார்ட் பண்ணி இப்போ உங்களுக்கு டவுட் வரக்கூடாதுன்னு என்ன பண்ணுவாங்க தெரியுமா கீழே சின்ன illustration கொடுத்தோம் அந்த illustration எப்போ டவுட் வரும் பப்ளிக் கம்பெனில டவுட் வராது. ஓகே பப்ளிக் கம்பெனி பெரிய அமௌண்ட் ஓகேன்னு இருக்கும் சின்ன கம்பெனி வருமா இஸ் எவ்ரி கம்பெனி. ஓகே எவ்ரி கம்பெனினா private company, foreign company, every company are included. Again, you may raise a doubt. OPC வருமா ஸ்மால் கம்பெனி வருமா ஸ்மால் கம்பெனி வராது இந்த டெஃபினேஷனே வராதுல்ல டேர்ன் ஓவரே வராதுல்ல அது அது வரக்கூடாது உங்களுக்கு டவுட் அது பட் யூஸ்வலி வில் கெட் திஸ் டவுட் வெதர் பிரைவேட் கம்பெனி வில் பி கவர் ஸோ டு அண்டர்ஸ்டாண்ட் திஸ் வாட் they'll do is just give a small example. Okay, Lata Private Limited, etc. will be given like some private company name will be given, and all these figures will be mentioned, and will be asking you to check whether you can understand. This is what you call as illustration. To understand that section, and it's not forming part of the section. Only for understanding purpose it is given. So they are considered of relevance and value in construing the text of the sections. To understand the section only, they are provided. Illustration cannot have the effect of modifying the language and can neither curtail nor expand the ambit. What do you mean by curtail? அதோட மீனிங்கை சுருக்கிறதுக்கும் அதோட மீனிங் எக்ஸ்பேண்ட் பண்ணுறதுக்கும் உங்களுக்கு ரைட்ஸ் இருக்கு. ஓகே example 13 I request you to go through. Next one, proviso. Already we have discussed earlier. Where we discussed here, General Process Act. Okay, I'm not going to go line by line. So when we say proviso, it's called as provided that. So ordinarily, I'm going for this line. Ordinarily, a proviso is not interpreted as stating a general rule, but it's considered as together. Usually, we'll get these three words. One is, I'll go for the next page. Can directly come for the next page. One is, when you say proviso, actually I had to compare this with exception and saving clause. We have to understand in three different angles. We say exception, except. Okay. So which means what? We have to rule out those cases. They say except means some particular cases should not be considered. Particular cases should not be considered. When we say proviso, is to remove special cases. Please highlight. Exception means to restrain. Restrain means restrict the meaning of particular cases. Proviso means to remove the special cases, provided that this company should have a net worth. அப்படின்னா அது கீழே இருக்க கம்பெனி எல்லாம் வேண்டாம். Okay, provided that means it gives a talking about special cases only. Whereas it will be said something called a saving clause. Probably, for example, you go for section 3, share capital clause. Okay, what is that? Whether the company can go for issue of shares. Okay, company having share capital, a limited company having share capital, procedure will be given. ஓகே அந்த ப்ரொசீஜர் அந்த கம்பெனி ஃபாலோ பண்ணும். அப்போ வேற எங்கேயாவது இடத்துல வேற செக்ஷன் நம்ம இருந்ததுன்னா இட் வில் பி given as a saving clause where you can follow directly that one. So saving clause is used to preserve. Please highlight. ரெண்டு இடத்துல ரெண்டு செக்ஷன்ல ரெண்டு மாதிரி இருக்கே இல்ல அங்க சேவிங் சொல்றாங்களா அதை தான் நீங்க ஃபாலோ பண்ணணும். So that section is preserved from destruction, certain rights, remedies or privileges. Probably I can take an example for this one. Let me check. Actually, it will mention as saving itself. This one, section 61. Sorry, I said 63, section 61. This is what you call as a saving clause. Power of the limited company to alter its share capital. Whenever you talk about altering the share capital, this is for which company? Only for limited company. So whenever you go for altering the share capital, you have to follow for amendment of MOA and AOA, where you follow section 13 and 14. But when we say there is a limited company and that company is altering a share capital, means you go for section 61. So 61 is a saving clause. அப்படின்னா இங்க இருக்கிற the rights வந்து preserve பண்ணணும். இங்க இருக்கிற செக்ஷனை மீறக்கூடாது. Which means this section will be having the overriding effect compared to other sections. Even though sections 13 and 14 is completely dealing with amendment of MOA and AOA, this section 61 is particularly dealing with share capital of the company, altering the share capital of the company. For which company? Not all the company, limited company. Okay, so they say this will be a saving clause. Okay. Actually, you'll find that word as saving. I'll show you. See, same as provided in section 161. You remember this one? We were discussing in detail with respect to alteration of MOA and AOA, all the different clauses under MOA. Okay, you just don't consider this word. We think as if the save as provision is not there. How you read it? Just write a company may by special resolution and after complying with the procedures specified in the section alter the provision of this memorandum. அப்ப எல்லா கம்பெனி மாதிரி அந்த கம்பெனியை ட்ரீட் பண்ணுவீங்க. இப்போ இந்த லைன் இருக்கிறனால save as saving clause இங்க இருக்கிறனால what are you doing? Save as provided in section 61. அப்போ உங்க கம்பெனி என்ன கம்பெனி? Limited company. What is your state? You're going to alter the share capital. Here they say save as provided in section 61. Don't refer 13, go and refer that. Which means you should not refer 13 னு சொல்ல வரல. அங்க இருக்கிற ப்ரொவிஷன்ஸ் டிஸ்டர்ப் பண்ணக்கூடாது. அப்படின்னா அங்க இருக்கிற ப்ரொவிஷன் ஸ்ட்ரிக்டா ஃபாலோ பண்ணா இதுவும் ஃபாலோ. Again, it's a beautiful section. Okay, let me continue. So that's about saving clause, which means it's actually preserving clause. So some of the section should not be disturbed. So that privileges should be enjoyed. Okay. Next, let me go for explanation. Yes, some explanations will be given. So an explanation should normally be read as to harmonize. What do you mean by harmonize? Not to get a conflict. Okay. With and not harmonize with and clear up any ambiguity. So if you get any confusion, if the words are not clear, then you go for the explanation and you understand. So usually I'll be discussing this one. Share capital means what? Includes both equity and preference. If it is mentioned as paid up equity capital, then we are talking about equity capital. Okay. Okay. So it will explain the meaning and intentment of the act, why it is being there, clarifies any absurdity, which means any vagueness or anything not clear, like provides an additional support, fill ups the gap. Yes, please highlight this one. அந்த இடத்துல இந்த explanation இருக்கும்போது தான் it will give you more meaning. Okay, so that's why we need it. And yes, please highlight the fourth point also. It cannot take away statutory right. அதுல explanation இருக்குங்கிறதுக்காக அந்த full actல இருக்கிற விஷயத்தை வந்து ரிமூவ் பண்ணிட முடியாது. Obviously, it will not have a overriding effect. That's what I say. Next, I'll go for schedules. Is for all purpose of construction, we have to read together. When we read together, please consider reading the schedules also together because they are forming part of that. அது ஓரமா அனெக்ஷன் பண்ணி கொடுத்துருக்காங்க யார் படிக்கணும். Okay. Usually this will be the basic question, probably not at inter level. Which schedule is covered or which table is covered for MOA and MOA? This will be the basic question. In 11th, 12th, வந்து MOA, AOA table numbers கேட்டிருப்பாங்க A, B, C, D. Okay. So schedule cannot control or prevail over the expression. It's not controlling or it's prevailing or it's not giving any clarity and all. If anywhere in the wordings, in the sections you say, you find that follow the schedule, that's follow the format, you follow it. அவ்வளவுதான் வேற எதுவுமே இல்லை. It's like an attachment. Instead of giving together in a single page, they are attaching at the end. Okay. So if there appears to be any inconsistency between the schedule and the enactment will prevail. இதெல்லாமே எய்ட்ஸ் தானே. இப்படிதான் ப்ரிவேல் ஆகும். ஓகே. சப்போர்ட்டிவ் இதுதானே பார்க்குறோம். ஓகே. Read the statute as a whole. I think this is the 10th point. Even though we have different headings, different parts, please take it as one single content. Don't break it. The breaking as different chapters or different sections is given for you to understand and for applicability purposes. Okay, together are the. And when we talk about deed, the deed must be read as a whole in order to ascertain the true meaning of several clauses. Deed means agreement. We have different clauses. Please understand the same. So in this and all, you can normally go through. I'll go for this line, this particular line. One of the safest guide to the construction of sweeping general words is to examine other words. Please highlight. Sweeping means what? I'm not considering one word. Which word should not you are not considering? General word. Why you are not considering? Because there are some special words are there. Or you're importing some meaning from the same enactment. Please understand, not from different, same enactment. If you find any limitations are there, you try to import the meaning from same enactment, not from the outsider. Okay. And if you find that the number of expressions has to be subject to limitations and qualifications, means which one of the same nature that one has to be considered. எக்கச்சக்கமா disputes வரும். அப்புறம் நம்ம careful handle பண்ற மாதிரி. So if one section of an act requires notice should be given, then a verbal notice would generally be sufficient. Beautiful example பாருங்க. நோட்டீஸ் அதுக்குள்ள நோட்டீஸ் வரல கைக்கு வந்து சேரல கைக்கு இல்ல காதுக்கு வந்து சேர்ந்தா போதுங்கிறாங்க. Okay, verbal notice is sufficient, but this is in one section. But if another section provides that notice should be served, see, notice should be given is different from notice should be served. Notice should be served means what? Go and refer General Process Act. What do you mean by notice should be served? Register post அனுப்பணும், proper address இருக்கணும், proper stamping இருக்கணும். That's what you call as, which means what? It's an expressive notice. On the person or left with him or in a particular manner or place, then it will obviously indicate that a return notice was intended. Okay, so you just understand whether it's notice to be given or notice to be served. Okay, yes, we can just go to the other five. External aids. So far, we were discussing internal aids and 10 points were, okay, 10 headings were there. What's the difference between internal and external aids, sir? Internal means everything we look into the act only, into as the statute only. But whereas sometimes we have to look to get more clarity about 2013 Companies Act, we have to look for 1956 Act. To get more clarity about Indian Partnership Act, we have to refer Indian Contract Act. Why? Because these sections, not these sections, this act is completely subsumed from Indian contract. Okay. அப்போ இந்த ஆக்டோட ரெமெடி இந்த ஆக்ட்ல இல்ல. If you get any doubt, probably it's somewhat looking like mischieful. What was the act earlier? What is the act now? Okay. So if you want to get more clarity about Indian Partnership Act or SOGA Act, SOGA pakadinga, Salem Goods Act, then you have to go and refer what was there in Indian Contract Act and why it was repealed, okay, and subsumed as a separate act and continued. So it's general intro only. Society doesn't. Okay, I'm not going line by line. Okay. So let me go directly over here. What are the external aids we have? Historical setting. What's the background? Okay. Sometimes we'll be consolidating statutes and previous law, like 1956 Act. Go for the very first line of 2013 Act. You'll find that it's consolidating and amending the earlier laws. I'm referring the Bar Act. Once again. Okay, that's in draft. Okay, no issues. I'll just carry on here. So when you want to go for referring 2013 Act, it's nothing but consolidating previous law and statutes. So this is referring with 1956 Act. What's the usage? For what purpose? For example, we have RTI Act. Right to information is your fundamental right. Okay, but we have a separate act for this, which means we want to take the proper usage from the fundamental right. That's why. So we need to get proper awareness and knowledge. Then earlier and later acts and analogous acts, which means what was the earlier act, what's the current act that's repealed and other cases. Dictionary meaning sometimes we take, usually when we say dictionary, if it is a normal plain language, you take the English meaning. If it is particularly dealing with legal legitimate values, then you go for referring general clauses act. Okay. Use of foreign decisions. Now follow பண்றதுனா foreign acts தானே. Okay, very first law we discuss in Companies Act is Solomon is a Solomon company. Okay, so it's not our Indian case law. We are referring foreign issues. Okay, so historical setting. Please highlight the history of the external circumstances. Something led to make this as a statute. History and in general. So somewhat after some 3 or 4 lines. History in general and parliamentary history in particular. Please highlight. History na நம்ம படிக்கிற history இல்ல in general. But because of that historical background only we have something. So history in general. And what do you mean by parliamentary history is we have a bill. Okay, a committee is formed. What was the recommendations given by the committee? That was about the parliamentary history. What was the what background happened? What were the suggestions made by the committee? What was taken by Lok Sabha? Why it was taken? Why it was not taken? If not taken, what suggestions were made and what other alterations were done? And how did it go to other house, Rajya Sabha and other things. Okay, so Asian statutes has to be considered. Not only parliamentary history, Asian statutes, contemporary or other authentic works and writings, all are relevant in interpreting and construing an act. Okay. Second one, consolidating statutes and previous act. So it's an act to consolidate means you have to follow the previous law and also the current one. Okay. We have to follow the previous and also the current one. Okay. So they may solve doubtful points in the statute with the aid of such presumption. Please highlight. Because when we say it's consolidating the previous act, we are applying the previous one also. So it becomes a presumption that with no doubt you apply it. No question, raised, you apply it. Okay. Rejecting the literal construction. Usage is sometimes taken into consideration in consuming. So how that language was interpreted and why we use that language. Okay. அந்த நான் சொல்லியிருக்கேன் அந்த ஒரு வேர்ட் இருக்குன்னா அந்த வேர்ட் சும்மாலாம் போடலாம்ல. That words there means some usage should be there. Without knowing that usage, why you take it? Okay. Likewise, act is there means there was something happening and that's why we have that. Okay. Why we need to have IT Act? IT means Information Technology Act. Okay. யாராவது ஒருத்தங்க தப்பா சொல்லிட மாட்டாங்கன்னு நினைச்சேன். Thanks for that. IT Act, Information Technology Act. Why we need to have Information Technology Act? உலகம் ஃபுல்லா ஜஸ்ட் கிளிக் ஆஃப் அதுல வேலை நடந்துட்டு இருக்கு. நம்ம மட்டும் வந்து பேப்பர்ல பண்ணிட்டு இருப்போமா? Okay. Also, I'm not going line by line. Earlier and later acts and analogous act. Exposition of one act by language of another. To understand one act, you have to understand different acts. Then you can do also. For example, to levy penalty and other punishments and all, we go and refer criminal procedure code. It gives a procedure how you have to carry. If it is a crime, I discussed this word earlier. Mens rea should be there. I discussed this earlier. I don't know to which batch I discussed. Mens rea na மைண்ட்ல வந்து கிரைம் பண்ணுங்கிற இன்டென்ஷன் இருக்கும். ஓகே, ஒருத்தரை போட்டு தரலான்னு வந்தீங்க. எப்படி வந்தீங்க? வீட்டுல இருந்து அருவாலாம் பேக் பண்ணிட்டு வந்தீங்க அப்படின்னா your intention is to defeat him, which means murder him. Okay, you did not have any plan. அப்படியே கேஷுவலா வந்தீங்க. அங்க பிரச்சனை நடந்தது. பக்கத்துல வந்து ஒரு இளநீர் வெட்டுற அம்மா வந்தது. அவங்களோட கத்தியில இருந்து எடுத்து வெட்டிங்க தலைய இளநீர். This is what you call as mens rea, which means what? You have the intention of wrongdoing. If you have the intention of wrongdoing, only you can say this as crime. This is as per Indian Penal Code. So whenever you talk about a crime has happened, what is the procedure you have to follow? FIR file பண்ணோம், evidence collect பண்ணோம், போலீஸ் சார்ஜ் ஷீட் கிரியேட் பண்ணணும். சார்ஜ் ஷீட்னா எந்தெந்த ஃபால்ட் என்னதெல்லாம் கவர் ஆகுது. சார்ஜ் ஷீட் கிரியேட் பண்ணணும். So everything has to be covered. Okay. And you say whether this is crime or not as per Indian law, which means you are not referring one, you are referring more than one code. So exposition of one act by language of another. So probably different types or different statutes may be there, and everything has to be considered pari materia. That's an analogous case. Analogous means each and everything has to be given equal importance. Pari materia. Okay, pari means equal. Okay. So if two acts are to be read together, then every part of each act has to be construed as if containing one composite act. Please highlight. Especially, we can talk about Companies Act. Companies Act is a overall everything is covered. Management and administration, shares, debenture, charges, dividend, everything is covered. Okay. But what happens here? For each and everything, we'll be highlighting this word called as digital signature. Okay. All the notices can be sent through mail. அப்ப எந்த ஆக்டையும் சேர்த்து பார்க்க வேண்டியதா இருக்கு இந்த இடத்துல ஐடி ஆக்ட் ஐடி ஆக்ட்னா information technology act. Okay, see, to understand this, actually that's not giving a different meaning at all. This is a separate act, that is a separate act, but together we have to, yeah, okay. So when we have this information technology act, the bank passbook எல்லாம் இ பாஸ்புக் எல்லாம் இருக்குல்ல அங்கெல்லாம் சேஞ்சஸ் பண்ணவே இல்லை பட் ஆட்டோமேட்டிக்கா மாறும்ட்டான். இந்தியன் எவிடன்ஸ் ஆக்ட்ல சேஞ்சஸ் பண்ணவே இல்லை ஆட்டோமேட்டிக்கா மாறும்ட்டான். ஓகே, ஏதோ ப்ராஃபிட் கால்குலேஷன்ல ஆஸ் பர் இன்கம் டாக்ஸ் ஆக்ட் கால்குலேட் பண்ணணும், கம்பெனிஸ் ஆக்ட்ல மாத்த மாட்டாங்க. இன்கம் டாக்ஸ் ஆக்ட் மாத்திரம் இஸ் அண்டர்ஸ்டுட் சேஞ்ச் இன் கம்பெனிஸ் ஆக்ட். இல்ல மேம் நாங்க வந்து கம்பெனிஸ் ஆக்ட் தான் படிக்கிறோம், கம்பெனிஸ் ஆக்ட்ல மாத்தவே இல்லை, இன்கம் டாக்ஸ் ஆக்ட்ல தான் மாத்திருக்காங்க சொல்லி யூ கேனாட் ஆர்கியூ. தட்ஸ் அபவுட் த two acts read together to give one single meaning. You should not read as two different acts. You should read as single act. Anyway, there are two acts only. Meaning combined பண்ணி பார்க்கணும். That's what இங்க இருக்கு பாருங்க. If two acts are read together, then every part, see each and every part of each act, two different acts, read this act separately, that act separately, it's giving some combined meaning. Take that as one composite act. So you don't take this as Companies Act separately and IT Act separately, defining digital signature, mail communications and all. Take together as one single act. Likewise, securities. Likewise, if a company is a listed company, என்ன பண்ணணும்? செபியும் பார்க்கணும், செபியோட எல்லா ரெகுலேஷன் ரூல்ஸும் பார்க்கணும், along with Companies Act பார்க்கணும். Banking company, everything put together. Everything combined. Okay. But if there is some clear discrepancy, then such discrepancy may render it necessary to hold the later point. Okay. Which means what has been modified. இதுக்கு இப்படி இருக்கு, இதுக்கு இப்படி இருக்கு. என்ன modify பண்ணலாம்? Demat shares. Is it mandatory? Not always. Okay. Even though they say it's in dematerialized form, probably when you talk about the owner of the shares, who is the owner of the shares? Whose name is there in register of members will be the owner of the share. But register of members bookல demat share இருந்தா NSDL and CDS ஓட நேம் இருக்கும். அப்ப அவங்க தான் ஓனரா? இல்ல. அப்ப இந்த இடத்துல ஒரு டெஃபினேஷன் டிஸ்கிரிபன்சி இருக்கு. I give the money, I invested, I am the owner. He is holding my account as a depository and depository participant. How can I give him the ownership? அப்ப என்ன நம்ம பண்றாங்க? Legal owner, beneficial owner பிரிக்கிறான். Legal owner, NSDL, and CDSL, because as per the records, as per the law, it's called as legal owner. But as per the provisions of Depository Act and other things, we say that we are the beneficial owners. Okay, so this has to be interpreted in the same way as in the earlier. So when the later of the two acts provides the earlier act should, then if they are consistent means then give provisions and other things and all. Okay, so as I was discussing with the demat shares, they are discussing with respect to debentures. Okay, so you can go see this later. இது பார்த்துட்டு அப்புறமா இது பாருங்க. I have discussed this everything in detail. Okay. So earlier act explained by the later act is what we call as the pari material. Earlier act is Companies Act explained by the later act, Depositories Act. Okay, related to demat shares. Again, I'm not going line by line. You can refer this one. Reference to repeal act. Okay, so I go refer that act, then come back. Okay, not fully, only to that part. Okay, then dictionary meanings. Again, I'm not going word by word because everything is dealt clearly in General Process Act. Okay, அதோட repetition மாதிரி தான் இருக்கும். So I'm not going word by word. You can please refer it. Use of foreign decisions. Sometimes it happens. When we talk about law, we talk about custom law, we talk about by statute, and we talk about preceding laws. Preceding laws means something case happened because each and every single case cannot be incorporated as a law. Correct தானே? அதான் கோடு மாத்திருக்காங்க. ஒவ்வொருத்தர் என்னோட லைஃப்ல வேற மாதிரி நடந்திருக்கும், உங்க லைஃப்ல வேற மாதிரி இருந்திருக்கும். பட் the penalty or whatever is same only. The result is same only. அப்போ அந்த டிஃப்ரெண்ட் சுச்சுவேஷன்ல டிஃப்ரெண்ட் ஒகேஷன்ல டிஃப்ரெண்ட் சர்க்கம்ஸ்டன்ஸ்ல டிஃப்ரெண்ட் ஃபேக்ட்ஸ் இருக்கும்ல, அதை பேஸ் பண்ணி ஆக்ட் போட்டா எக்கச்சக்கமா ஆக்ட் இருக்கும். அதுவும் இந்தியாவுக்கு சொல்லவே வேண்டாம். டிஃபெண்டிங் ஆன் த பாப்புலேஷன். So what happens is we cannot have an act. So already something has happened. We make that as an act and we follow it. Okay, so we use foreign decisions. Probably Indian laws also we apply and foreign laws also apply. Foreign laws foreign decisions will be applied. And moreover, நம்மளோட constitution பார்க்கும்போது constitution of India பார்த்தீங்கன்னா we are following completely England laws. UK laws தான். அதனால வந்து யூகேல ஏதாவது நடந்தா அதை பேஸ் பண்ணி தான் நமக்கு. That's why our terminology is also in such a way designed. Okay, நம்ம ஊர்ல எவ்வளவு இப்படியெல்லாம் ஈடுபட்டாங்க. I was thinking that when I was doing my CS, அப்ப நான் யோசிப்பேன் நம்ம ஊர்ல எப்படியெல்லாம் இந்த மாதிரிலாம் இங்கிலீஷ் வச்சாங்க. See, if you go to another place, you will get that language. இல்லையா? நீங்க சென்னையில இருந்து தமிழ் பேசி பாருங்க. Okay. You go to Coimbatore, you go to some other place, the totally it will be different. Okay, that slang or the way they use the terms slang அதான். So நான் வந்து அந்த டோன் கூட ஒரு மாதிரி டிஃப்ரெண்டா சொல்லுவாங்க. நம்ம அப்படியே முடிச்சுட்டே இருப்போமா, நான் சொல்லி எனக்கு தமிழ் புரியாதுன்னு சொல்லி. Okay. See what happens is their culture is different and their culture is defined in terms of language. Our culture, obviously, our culture is totally different. Not cannot directly compare with England laws. But what happened is our constitution is defined from England laws. It goes in part with England laws. ஆனா என்ன அங்க இருக்கிற கிங்டம்லும் இங்க இல்ல. இப்போ அங்க பிரின்ஸ் அப்படி இப்படின்னு சொல்லி எலிசபெத் டயனா சோ அந்த பிரின்ஸ் ரூல் அதெல்லாம் இருக்கு, இப்பவும் இருக்கு. பட் நமக்கு அது இல்லை. அதெல்லாம் நம்ம ஸ்ட்ராங் ஆயிடும், தெளிவாயிடும். Okay. So that's about use of foreign decisions now. So how we are going to take the language of the Indian statute? Yes, Indian statute or language I have to give the importance. At the same time, to check whether it's legitimate to understand in a better way, we take the case laws, the decisions provided by the court. Okay. Yes, can you please go through? Just imagine we are two parties, X and Y. Okay. X, myself, the owner, and you're coming as a tenant. First thing, you'll have the heading for this deed or agreement. What do you call it? Either lease agreement or rental agreement. Okay. See, as per the law, giving as a lease or giving the right to occupy the property is my right. Whose right? As a owner, I have the right. இது ஜென்ரல் லா ஃபாலோ பண்ணி. ஆனா எவ்வளவு ரெண்ட், எவ்வளவு நாளைக்கு இருக்கும்? ஓகே, வாட் ஆர் த அதர் திங்ஸ் யூ ஷுட் நாட் டு? ஒரு ரூமுக்கு 2 ஆணி அடிக்கலாம். 3வது ஆணி அடிச்சீங்கன்னா 50 ரூபாய் ஃபைன். ஓகே, சரி இருக்குல்ல. ஒரு சில பேர் அக்ரிமெண்ட் பண்ணும்போது போடுவாங்க எத்தனை ஆணி அடிக்கணும். அதுவும் வந்து மந்த்லி செக் பண்ணிட்டு தானே போவாங்க. ஆணி கவுண்ட் பண்ணிட்டு எல்லாம் போயிருக்காங்க. ஓகே, இதனாலதான் இந்த பிளிப்கார்ட் மீசோலாம் டிஃப்ரெண்ட் இது கண்டுபிடிச்சாங்க போல இருக்கு, வேஸ்டிங் ஒர்க். ஓகே, see, something is happening between you and me now. You have to understand and I have to understand. It's nothing but entering into a contract. Consensus அப்படின்னு நம்ம சொல்லுவோம்ல, உங்களுக்கு எனக்கு புரிஞ்சா போதும், வேற யாருக்கும் புரிய வேண்டாம். But as per the law, you have to follow. See, that's deeds and documents. What are the things you are applying for the act as a whole? Internal aids, external aids, secondary rules, primary rules, everything will be applicable here also. One point we were saying, it has to be understood to that circumstance, to those things contemporary. Okay. அது மட்டும் இங்க சேஞ்ச் ஆகும். ஃபுல் கான்டெம்பரரி இல்ல, நம்மளோட கான்டெம்பரரி பார்த்தா போதும். Okay. Obviously, when they talk about it, they'll talk about the culture. Okay, they talk about the culture, they talk about they consider the age. What was the age? In the age போட்டிருப்பாங்க. So I request you to go line by line because I am going to travel here on line by line. Okay. Small idea to understand this content is, don't consider as separate deed and document. Consider this as separate putting act. Okay. For example, Companies Act. Wherever you find every company, don't think as every company. Think as my company. Okay. Any director, don't think as any director. A, B, C and director. So ABC and alone will be considered. So when you say deeds and documents, you're considering only to that particular person's particular situation, particular facts. அப்ப எவ்ளோ செக்ஷன்ஸ் வேணாலும் இருக்கட்டும். எனக்கு எது applicable அது மட்டும் தான் நான் பார்ப்பேன். At the same time, what are the rules of interpretations we are applying? Everything will be followed. Okay. So please join. The first and foremost point has to be borne in mind is that one has to one has to find out what a reasonable man, please highlight this word. What a reasonable man. Reasonable now, ஒரு rental agreement. என்ன விஷயம் இருக்கும் அதுல? That's about reasonability. Okay. Reasonable who has taken care to inform himself. Please highlight. நிறைய பேர் அக்ரிமெண்ட் போடுறது அவனுக்கு தெரியணுங்கிறதுக்காக இல்ல, எனக்கு தெரியணுங்கிறதுக்காக. ஒரு 100 வீடு இருக்கு. யார் யாருக்கு என்னென்ன கண்டிஷன்ஸ் கொடுத்தா எனக்கு தெரியணும்ல. Okay, whether it's 100 houses or one house, the situation is same. Okay, so who has taken care to inform himself of the surrounding circumstances of the deed or document and of his scope and intents would understand by the words. Please highlight. What's the difference between the act and the deed and document is actல வேற மாதிரி wordings இருக்கும், deed and documentல colloquial wordings இருக்கும். That's what we say a reasonable man. We are not lawmakers. Am I right? If you are a lawmaker, you have to understand the differences because you have to completely cover all the situations. But whereas I'm discussing about my house, me as the owner, you as the tenant, clearly I'm going to discuss my points only. I'll go as a reasonable man. So I define by particular words. Okay, எனக்கு புரியுறமா நான் போடுது. The principle of construction in case of document and deed as of statute does not differ so much except in some minor details. A deed must be read as a whole, like you did with statute. A statute has to be read as a whole. Likewise, a deed must be read as a whole in order to ascertain the true meaning of the several clauses and the words of each clause. So, it should be interpreted to bring them harmony. Harmony means what? Breaking the conflicts without conflicts. With other provisions, if that interpretation does no violence to the meaning of which they are naturally susceptible. கண்ணா பின்னாலும் வேர்டி சொல்ல வேண்டாம். பேசிக்கா என்ன தரணுமோ அது கொடுத்தா போதும். So these are the words given by Lord Watson. In all cases, endeavor shall be made to find out how reasonable and well-informed person would understand. Please highlight. இது ரிலேட்டடா கேஸ் ஜட்ஜ் கிட்ட போச்சுன்னா, the judge will not look as if it is an act. How the judge will look? யார் இருந்தாலும். என்ன age? Okay. These are the things only will be understood by the judge. Okay. Likewise, if you talk about any property dividing between the family members, எப்படி பார்ப்பாங்கன்னா, see, as per the law and calling, daughter and son will get the equal rights and everything is okay. But as per the act, even though you follow, what is the situation? So that the golden rule of construction. What's the golden rule of construction? Which is the golden rule of construction? Rule of literal construction. Rule of reasonable construction. That's the golden rule of construction. Is to ascertain the intention of the parties to the instrument after considering all the words. Usually when you go for an act, when you go for a statute, you have to consider each and every word. Likewise, here also you have to consider each and every word, but not giving the grammatical or not grammatical, the legal meaning. You have to consider this as ordinary and natural sense. So to ascertain this, the intention of the court has to consider the relevant portion of the document as a whole and also to take into account the circumstances under which the particular words were used and very often the status and the training of the parties. This is what I was saying. Our culture என்ன qualification and what is the age of the person in a reasonable manner சொல்லிட்டாங்க. கவனிச்சிக்கலாம் தெரியல. Reasonable man means person to person the reasonability will be differing. For me, I'll be having a different experience. We'll be having a different experience. So person to person it will be differing. Using the words have to be taken into consideration. And it has to be borne in mind that very many words are used in more than one sense, and that sense differs in different circumstances. Means you have to completely give a single meaning, so you need to have a trained conveyancer, like translator மாதிரி. Okay, என்ன மீனிங்ல இதை பண்ணிடுவாங்கன்னு சொல்றது. So it may not be reasonable and proper to give the same strict interpretation of the word throughout. Usually we'll go for beneficial interpretation only. So let me go directly over here. Yes, it is inexpedient to construe the terms of one deed by reference to the terms of another. Yes, please highlight one. If there is two acts, what we'll do? We'll refer this act, we'll refer that act, and we'll take it as one composite act. If you have two deeds, between two different persons. You should not consider as one composite deal. You have to consider as two different composite deals only. Myself X, yourself Y. We both are forming a company. We both are forming a partnership firm. Totally law is different here, law is different here. They may be the same parties to the two different contracts. But totally the different act is different, situation is different, business also may be different. வெறும் ரெண்டு பேர் வந்து சேம் பார்ட்டிங்கிறதுனால நீங்க ரெண்டு டாக்குமெண்ட் எப்படி ஒன்னா கன்சிடர் பண்ணீங்க should not be done. That's what they're saying. See, it is expedient to construe the terms of one deed by reference to the another. It is an elementary rule of construction that the same word cannot have two different meanings in the same term. So you cannot give us two meanings. Okay. So this and all is okay. And it may also happen that there will be a conflict also. So between two or more clauses, when there is a conflict, what you have to do? You have to go for the then it is the earlier clause that will override. ஃபர்ஸ்ட் ஒரு கிளாஸ் போட்டிருக்காங்க செகண்ட் ஒரு கிளாஸ் போட்டிருக்காங்க ஃபர்ஸ்ட் கிளாஸ்ல ஒரு ரூம்ல ரெண்டு ஆணி அடிக்கலாங்கிறாங்க செகண்ட் கிளாஸ்ல ரெண்டு ஆணிக்கு மேல அடிக்க கூடாதுங்கிறாங்க வாட் யூ மீன் ஓகே இட் லுக்ஸ் லைக் சம்வாட் சிமிலர் ஓகே அப்போ ஃபர்ஸ்ட் கிளாஸ்ல என்ன சொல்றாங்க ரெண்டு ஆணி தான் அடிக்கணும் ஓகே ரைட் similarly if one part of the document is conflicting with another part means yes please highlight an attempt should always be made to read the two parts of the document harmoniously ஏன் ரெண்டு லைன் இன்க்ளூட் பண்ணணுங்க ரெண்டுமே ஒரே கிளாஸ் தான் ஒரு கிளாஸ் போட்டா போதும்ல why we need to have another clause because it is needed over there which means what you try to resolve the conflict and give meaning to both the words okay both the clauses so if that not possible then the earlier part will prevail over the later one and the later should be disregarded not at over let me go for the summary ரொம்ப அழகா wordings யூஸ் பண்ணிருப்பாங்க let me go okay enacted laws acts and rules are drafted by whom legal expert. So, it is expected that the language used will leave little room for interpretation of construction. Or what do you mean by this line? சும்மா யாரோ ஒரு ஆளெல்லாம் உட்கார்ந்து அப்படியெல்லாம் ஒரு கமிட்டி எல்லாம் ஃபார்ம் பண்ணி பண்ணல தேர் ஆல் லீகல் எக்ஸ்பர்ட்ஸ் அப்ப லீகல் எக்ஸ்பர்டைஸ் நாலேஜோட தானே பண்ணிருப்பாங்க சோ யூ கேனாட் சே தட் இப்படி இருந்திருக்கலாம் நோ கேனாட் டூ தட் see interpretation means you are giving additional meaning but you cannot say that it gives only a little room means you cannot wider give explanation for that. You have to go very particular sense, strict sense. So interpretation or construction of statute helps in finding the meaning of the ambiguous words and expressions given in the statutes and resolving inconsistency like if any provision of the statute is open to two interpretation, this is not is okay. The best interpretation is possible only by adoption of various guiding rules of construction. The 7 primary rules, 2 secondary rules. They strongly lean against the construction which reduces the statute of futility. Okay, this is not normal. Okay, this is not normal. I just wanted to give this important lines to understand a better way. Okay, so that's about this topic. Yeah, thank you.